Okay, everyone. So let us start. Um, See, someone have asked me a question, I suppose, right? One question is there in the chat box itself. Let me first handle it. That is an interesting question, actually. Most of you won't be knowing it, right? So the question is that can you tell me the difference between executive and administrative power, right? Because that is a very critical question I observed, right? See, when we say executive power, it is basically power conferred by the constitution. Okay, you must be remembering that Ram Javaya Kapoor case, right, where the court held that when we talk about executive power, then it is basically defined in a residual format, meaning when you strip away the judicial and the legislative power, whatever is left is the executive power, right? Now, administrative power simply means that when a statute confers upon you a particular power, right, within the administrative system, right, within the administrative law, that is referred as administrative power. Okay, now there are few points where the executive power and the executive power, administrative and the executive power overlaps, right? But there is a very fine difference between these two. Okay, so that was a very good question whoever asked, Mr. Sudarshan. Okay, so I hope you understood the difference. Okay, yes. So let us start with the today's class. See, uh, if we see the today's class, then today class we are basically covering five topic, right? Sorry, two topic. Now those two topic are basically topic number 8 and topic number 10 of the constitution. Okay, so of the constitutional law syllabus. Okay, now what are those topics? So let us see. Services under the union and states, right, very comprehensively defined. Recruitment and the condition of service. Okay, so what are the condition of service, what the government can do with respect to that particular condition, that is actually important, right? And we will see that that is there in the part in the syllabus as well. Then constitutional safeguard, right, to civil servants, that is not mentioned but indirectly it means constitutional safeguard to civil servants, right? And then the administrative tribunals, so specifically administrative tribunal. However, in last 5 years there has not been much question on that, but obviously if it is given in syllabus you have to study it. Okay, you cannot skip that particular part. Okay, so that part has to be studied. Now someone is saying no audio. I think everyone else is getting the audio, right? Yes. Okay, so Mr. Avlas, there is some problem from your side, you fix it up. Okay, then there is topic number 10, that is your Union Public Service Commission, State Public Service Commission, power and function. Very straightforward topic, right? It is not something which you need to be dwelling a lot upon, but obviously I will talk about that as well. Okay, so let us start. So these two topic can be divided into 4 subtopics actually, right? So I will go into detail into each subtopic, and I will also go into the case laws that is there, or some of the concept related to those topics, right? So that it will enable you to study by yourself. Okay, see, first subtopic is basically civil servant meaning, right? The meaning of the civil servant itself, right? In the previous classes, I mean in the previous questions paper, you must have seen there is a direct question that what do you mean by the term civil servant. Okay, so that is not given exactly in the syllabus, but there have been questions on that, right? So you have to understand the meaning of civil servant, right? There is lot of philosophical aspect of it, and specifically in the case of paper 2, right? There was a paper question, if I remember correctly, in 2018, that how the structure and the behavior of bureaucracy have changed after the globalization, right? After 1991 liberalization. Okay, now the structure and behavior both are separate thing. In the case of bureaucracy, that is the civil servant. Okay, understood, right? So the meaning of civil servant can be clubbed with the preparation of GS2 paper topic itself. Okay, so in our law syllabus there has been no question regarding this type, the GS paper 2 one, right? But there have been question regarding civil servants, right? Let me see you previous year paper. In fact, I have written here also one question. Define the term public servant. Okay, not civil servant but exactly public servant. Also discuss the recruitment procedure of the public servants in India, right? Basically they are referring to civil servants only. Okay, so that is one very interesting thing. Okay, so that is the meaning, right? Philosophical aspect of civil servant. Now you must have seen, right, the behavior of bureaucracy, the structure of bureaucracy, right? That legendary line, the steel frame of the nation, all sort of stuff, right? And behavior, right? Mostly in our country, civil servant basically talks about feels like the citizen and them, the relationship is of master and servant. Okay, so that is the behavior we are talking about, right? Not the structure but the behavior. Structure is a different thing from behavior. Okay, so that philosophical aspect. Yes, someone is asking me the this from where you should get it. So I had one book, I think last year I brought a very interesting book. I don't know it is in this office or it is in my actual office, right? And that book was related to civil servant only, right? The name of the book was Civil Servant in India, Steel Frame of the Nation, something like that. I don't have that book right now, but that is a very interesting book actually, right? So if you can actually read it, that book now. I cannot find that book, right? I have that book. That is a very good book. Okay, so that book actually you can refer to. Okay, Ishan. So that is a very good book. I don't know where this book is, right? I had this book actually. I will say it. I will definitely refer to you this particular book, right? That is a very good book actually, related to civil servant only. Okay, so that you can actually go through it. Okay, then second subtopic that we will come to is basically constitutional safeguard related to civil servants. Okay, now what is the meaning of constitutional safeguard? Okay, see, if you will see the constitutional safeguard, there are 3-4 important constitutional safeguards. So you have to go into detail, like power to make rules, doctrine of pleasure 310, delegation of the doctrine of pleasure by the governor or the president to the officers subordinate to them. Okay, so that particular part is also important. Okay, then you have to go not only to these doctrines but the case law related to those doctrines in detail. Okay, so in case laws, even for each and every safeguard, if you remember, if you can read 2-3 case laws, that will suffice, right? So if you go through the this MP Jain or any whatever VN Sukla you might have, so they have the whole 7 to 8 9 pages of case law. Just pick 2-3 of them, any 2-3 will do. Okay, just the important aspect, because they never go specifically into that. Okay, suppose there is a question related to doctrine of pleasure, so they cannot go into one aspect of doctrine of pleasure. A very general question will be asked. Okay, what is doctrine of pleasure? What are the exceptions thereof? Suppose, right? So if you pick any 1-2-3 case laws, that is more than sufficient. Okay, because doctrine of pleasure obviously have multi-dimensional approach, right? There are multiple sub parts of that. That you need not to study for law optional at all. That might be relevant for judiciary, but not for law optional. Understood? So that particular point has to be kept in mind. You have to read it generally, and important case laws 2-3 will suffice, right? Not more than that. Okay, so 2-3 will suffice. Okay, so that particular point you should keep in mind. Okay, then another, dismissal, removal and reduction of rank, right? So what is the meaning of reduction of rank? What do you meaning of dismissal? Dismissal, does it mean final dismissal, or it also include temporary dismissal, right? So all sort of thing related to that dismissal, right? So that has to be studied in a good manner. Okay, so that is a very important actually aspect. Then inquiry and the procedural requirement of 311(2), right? You must have seen, if the inquiry has to be held, then automatically all the provision of the administrative law will apply. Meaning, these all has to follow the procedural requirement given under 311 clause 2. I will discuss also that in detail. Okay, and also the exceptions thereof. Like one of the exceptions is that if you are convicted by a court of law, right, then no need to follow those procedural inquiry. Ultimately, you can be dismissed, right? So that is one of the exceptions. Okay, or with the reason recorded in writing, it is not feasible to have feasible to conduct an inquiry, right? Because that has happened. One time you must have, I don't know if you have heard or not. Fakhruddin Ali Ahmad, when he was the president, right, his daughter has an affair with one of the officers who was guarding them, right? Army officer actually, right? Now the question arose that in that case, can the inquiry be done, okay, before dismissal, right? So that will be embarrassing for the president, but obviously Mr. Fakhruddin Ali Ahmad is a very large-hearted person. So when he came to know about this whole proceeding, he called that particular guy, right, that officer, and finally then get married to that, his own daughter with that officer. So that is a separate issue, but really it is a right. So those sort of situations, embarrassing situations, right, where the inquiry is actually not practicable. Yes, Deepak Gupta's book, very correct. You are very right. Steel Frame of the Nation. It is a Deepak Gupta's book, right? And I can't find it. I had this book here itself, right, but I don't know where it is kept. It is there. It is there. I have read it around 5-10 days back itself. Something I was writing, so I had to refer that particular book. So it must be kept somewhere. Okay, it is there. It is a very good book actually, Deepak Gupta's one. Okay, you can read that. Okay, right. So that is the exception part that I am talking about. Okay, so those exceptions has to be studied. Then there has not been much question about UPSC literal provisions. They don't ask much question about directly from UPSC, no, right? But you should go into the provisions of UPSC, right? The specific provision with respect to its function. Now, if you will look at the article related to UPSC 325, 24, 25. So you will see that they specific provide not 16, 17, 24, 25 elections. Okay, so then you will see that there is a specific functions related to not only conduct of examination but also publishing a report to the president, and also there have been question, there is a function related to that whenever there is a transfer has to be initiated or promotion has to be initiated, UPSC must be consulted. Then what is the value of that consultation? Does that consultation mandatory? If the answer is yes, then is it binding? Okay, so you have to go into the literal provision of the UPSC function, right? Let me show you in the constitution itself, if I have here, right? So if you will look at the constitution, what actually I am telling you, see, let me go to the, I think, no, it is 300 and something. Let me open it. Sorry. 300. Let me show you so that you will understand it nicely. 300. Okay, it is 200 itself. Constitution is also too long, I suppose. Yes, 311. Yes, dismissal. Function of the UPSC, it will be in part 2. Yes, UPSC. Appointment. Yes, removal, power, prohibition of commission. Yes, function. See, this is what actually I am talking about. The UPSC and the state PSCs, as the case may be, shall be consulted on these things, right? So if you are reading paper 2, you need not to study, but for law optional, you have to study it. Okay, so that is a very, very relevant point here. Okay, right? What is the value of this consultation? Is it mandatory to consult while performing any kind of recruitment, change in the method of recruitment? Like we have this news that optional will be removed and a new law paper compulsory will be added, administrative law paper, right? So these type of rumors, right? So obviously the UPSC must be consulted. Similarly, all disciplinary matters. So is it mandatory? Suppose UPSC is consulted and UPSC somehow do not give the recommendation to prosecute an officer. So is it binding on the president? Okay, so that is one point actually I was referring to. So the functions, is it discretionary? And once this function is exercised, the advice is given, thus that advice is binding on president or the governor, as the case may be. Okay, so that particular point you have to go in detail with the case law, right? So for normal GS paper 2, simply reading this will suffice, but for law you have to little bit go in much more deeper. Okay, so that is what I was saying here, that UPSC in its literal provision, it's each function in detail along with the case law. Okay, so that part you have to keep in mind, that you have to go through it, right? Now if you will see, there is always a question with respect to civil servant, no matter which year. One question is confirmed, right? It might be from any of these aspects. It might be philosophical aspect of civil servant, it might be literal aspect of the civil servant, but one question is almost mandatory sort of. Okay, now what I will do, that I have taken some of the important concept related to it and tried to expand it for you, right? So it may help you. First is the doctrine of pleasure, right? It is based on the British common law, that you must know. See, let me little bit explain about the British, because all of the system basically comes from British. See, in British we used to have, still we used to have king, right? Or the queen. Now what they used to do is they used to basically command, right? Now when they used to command, then obviously those commands were referred as writs, and that is where we have this writ jurisdiction, right? So we used to have a king's court or a queen's court. So they used to order, they used to issue orders, and the writs used to be issued by the king, right? So the writ could override the orders of the court. Okay, so the same thing happens in India as well. Writ is some sort of a superior order, right? Now these king and queens used to appoint some of the officers to do their business. Now those officers cannot claim that, okay, why I am being removed, right? So that is where the doctrine of pleasure came into picture. That whatever the king is doing, he is firing someone or say he is firing someone, right? Then it is for the greater public good, right? So whatever they are doing, you cannot question them. That is from where the the doctrine of pleasure actually evolved, right? So that is why we write here, under the crown is held the pleasure of the crown, and it comes from, doctrine of pleasure comes from a Latin phrase durante bene placito, which means during pleasure. So as long as I want, right? So if I do not want you to be my servant, it means I am thinking of the public, that you are not serving public well. Understood? So in that aspect, this doctrine of pleasure basically have been evolved, right? So this historical or sort of philosophical aspect has to be understood. Okay, then this doctrine of pleasure is not absolute in our case, right? It is channeled by, safeguarded by some of the provision in the constitution. So even if the civil servants technically is on the doctrine of pleasure, right, but still they cannot be fired as whim. Okay, it means there are some of the constitutional safeguards, right? So the doctrine of pleasure is connected with the constitutional safeguards. Okay, so that particular point actually you have to understand, the technical point if you ask. Similarly, may be dismissed at will. There is no need to assign any reason. He could not even claim arrears. These all things are in the case of British, right? In India, these things are not applicable right now. Neither he could claim any damages for his wrongful dismissal. Okay, it means that whatever king is doing, it is for the public good, right? So no need to explain anything. That is where the doctrine of pleasure came. Okay. Now it is based on public policy. Now these are the lines actually you can write in the answer itself if there is any question with regard to doctrine of pleasure. Okay, so that is why I have given it. Obviously it is a very shorter version, but still. Public servant whose continuance in office is not or in against public interest should be relieved of his office. That is the philosophy on which it is based. Okay. Similarly, okay, so that is all about the doctrine of pleasure. Right now, one more thing I have given you, that one of the you can say safeguard against the doctrine of pleasure is the procedural requirement. Okay, so when you remove someone, right, then in our constitution article 302 provides reasonable opportunity of being heard has to be given, right? So the court have went into detail that what is the meaning of reasonable opportunity, right? So all kind of procedural requirement you have to satisfy, and that too meticulously has to be satisfied. Okay, it means that all the provision of administrative law will apply here. Notice देना होगा, witness can be re-examined, everything, every provision in the administrative law is automatically applicable, right? So I have actually pinpointed some of them. See, a specific charge has to be framed, it should be clear, precise. ऐसा नहीं कहे कि आपने you passed a notice that okay you have done something wrong. What wrong I have done, right? It has to be specific. Okay, reasonable opportunity, right? Time frame it is talking about, 2 days, 3 days, 5 days, whatever, right? Informed evidence also, all evidence will be given in his presence. He can cross-examine the witness or adduce additional evidence. The decision must be based on fact and material placed before the inquiring authority. Okay, so inquiring authority cannot say that okay I have heard something about you. No, he have to take the judgment only on the basis of fact presented in the front of him. Okay, the multiple case laws related to it, right? You can see, I think one of the state of Haryana versus something, I don't remember, I'm not getting that, Ram Kumar or something, right? When a constable was dismissed, okay, not constable, superintendent of police was dismissed. Okay, so the inquiry committee basically passed a remark that I have heard bad thing about you from your superiors. So right, so that the court held that this is basically something which was not there in the time of proceeding, right? So it is something which is extra proceeding. Okay, I mean extra evidence or the extra material collected not during the proceeding, so the judgment cannot rely on that one. Okay, so passing that one remark basically vitiated the whole proceeding, and that particular proceeding was quashed. Okay, then similarly 309 is another one of the safeguard provided, right? So 309 is basically rule making power of the president and the governor, right? That they can make multiple rule with regard to civil services. Okay, now what are those rules that they can make, right? So obviously, does it mean they can make any rule? No, the court have held in multiple cases that these rules must follow these things. What? So it should not violate fundamental rights. Okay, so this is basically related with this itself also, right? Here I have told you in the first part itself, delegation of the pleasure by the governor, right? So if you delegate something by the rules that okay the appointment will be done by this officer, so you are delegating it and you are claiming that it is a rule under article 312, okay, 309, right? Then obviously that rule must satisfy, that delegation must satisfy the requirement of different case laws, right? The first is it must not contravene fundamental right, okay, because that have been considered a law under article 30. Okay, this is the name of the case. Similarly, the rules should also comply with directive contained in 389D, right? So the directive principle of state policy must come from it, because the court have held that the rules that you make is basically a policy. Now it is the duty of the government to adhere to DPSP whenever they frame a policy. The policy may be with regard to civil servant or the otherwise, but the policy must give due regard to DPSP. Okay, so it means it must follow the requirement of DPSP. Okay, equal pay. In this case, equal pay was not given. Similarly, the legislative power or rule making power conferred is subject to Article 301, which incorporates doctrine of pleasure. Okay, right? So that is another important interconnection between the doctrine of pleasure and this. Similarly, 3 which contains procedural safeguard, that should also apply, right? You will make rule, but that rule should not violate the procedural safeguard accorded to Civil Service Order 311. Similarly, separate provision have been made for regulating these officers, right? Separate provision have been made for the case of Supreme Court officers, High Court officers, legislative officers. Then these rules will not apply to them. Okay, so these are the 5 points you must remember. Now I have tried to be very brief. Obviously multiple case law has to be read in that regard, okay, but I have tried to be very brief, okay. So that is an important part of 309 that you have to study. Understood that point? Now let us go to some previous year questions and try to understand. First question I have discussed itself, right? What is the meaning of public servant? Now anyone can here tell me what is the meaning of public servant? How do you define? Yes, any law which defines public servant? Constitution also do not define public servant. Yes, IPC is correct. Any other law, but specifically public servant. Prevention of Corruption Act, PCA, that also defines public servant. Okay. Yes, that is correct. Okay. Now, what is the general definition of public servant? Mostly, the general definition is that if you are taking money out of consolidated fund of India, right, then you are public servant. That is the general definition. Obviously, there are multiple sub-part of it as well. If you are a servant of PSU, then also, even if the money do not come from the consolidated fund of India, right, but still, you will be considered as a public servant. Okay. In General Clause Act, public servant, I don't know. It might have been defined or it might not have been. Okay. Civil Service Rules of Conduct. No, this simply says it is the public servant is there, but the public servant is as defined in these acts. Okay. So directly do not define. Okay. Right. Now let us come to the second question. Doctrine of pleasure incorporated in the Indian Constitution. With respect to civil servant, highlight the safeguard. See how simple question, a repetitive question. After each 1-2 years, this question is repeated, right? So that is why I am saying, right? Today also I made some of student called me, or I in fact called them with regard to that law optional, right? De facto wise people send them their name that they want to talk to me, right? So there also I told the same thing, and I keep repeating it, that 30% of the question are basically repeated ones, 30 to 40%, and this is one of them, right? So you should have a model answer for them. Beforehand you provide a model answer for them, right? So that is one thing you should understand. Okay, Akanksha is asking civil servant and public. I told you it is a misnomer, right? So whatever there is a provision for civil servant that is used in the constitution, right? Public servant is much wider than the civil servant, right? So civil servant is slightly, you can define it something like this. This is the public servant and this is the civil servant. Right? All civil servant comes under public servant. Okay, so civil servant is specifically with respect to constitution. Okay, Akanksha, done? Yes, Prevention of Corruption Act. Yes, that also provides for meaning of public servant. Okay, then doctrine of pleasure in relation to the same question, right? Repeated multiple time. It is repeated, right? Discuss the constitutional safeguard respect to dismissal, removal, procedural safeguard that I just discussed, right? 311 clause 2. Rank employed in civil capacities, again do the safeguard override doctrine of pleasure? Obviously the answer is no, do not override, but basically protects or waters down the doctrine of pleasure. Okay, so override is a tough word actually. Similarly, reasonable opportunity of being heard. See, in the last 7 years, right, 5 years, all the questions, see the two questions, these are same. Similarly, these two questions are same, almost similar. Right, so almost the question is repeated, right? So practically whatever the subtopic I told you, there is nothing to be studied apart from it, right? So that is more than sufficient actually. Okay, right? So I will award you the same question, right? One question I will ask you to do is basically question number 2. Try to do question number 2 here. Okay, so write it down. Let me plane it down. Yes, question number 2 you will solve and send me. Okay, explain the doctrine of pleasure incorporated in the Indian Constitution. In respect of civil servants, highlight the safeguard for the protection of civil servants. Okay, so it means you have to write down all the major safeguard, right? So you go study for 3-4 hours, all the major safeguard, case laws, and you write that down, right? And make a model answer for that. That you will, practically write in mains. Okay, so that is a very good exercise actually. Done, everyone? Yes? Okay. Now what I will do, that I will check some of the copies that you have sent me, right? So again, I have selected 5 copies, 1, 2, 3, 4 copies, not 5. So I will only check 4 copies, right? Now I have tried to be random, right? So I'm not repeating the copies, right? So I'm taking new copies each day, okay? So that everyone will get chance, okay? Because I do not check all the copies, okay? Yes. The question was, the federal government is a legalistic government, characteristics, feature, powers between center and state. Explain the provision regarding. Okay, good. Philosophical type of question. Federal form government with the powers are divided. Okay, very good. Good introduction. These are certain provisions. Okay, so we have talked about legislative power. Okay. Yes. Good. That is why I told you, do not write article exactly, right, but write in brackets. Okay. So very nicely he or she have written. But okay. And these all, again make it shorter, right? I've told you write in lines and make it shorter. It is like saying that you are trying to occupy the pages. Okay. So make it shorter. Okay. This I think you have already mentioned above, right? 254. Okay, no, you have not mentioned. Okay, then it is okay. Sometime may not be fair play, bona fide. See here the word, the legal word that you are using is too simplistic. Okay, so you should read more, you should use more legalistic words. Okay, it is very simple that you are writing in your own language. Okay, I told you, you cannot have that much ability to write beautiful lines, right? So it is better to, read authors and try to copy it itself. Okay, because you are not doing PhD here, right? So in 1 year you cannot expect yourself to writing good lines. Okay. Why to write this? Why to mention it? No need at all. Not asked. This is totally separate topic. Okay, totally separate. It is basically administrative power. Okay. Good. Relevance, yes, very good. Good. Uprising between the states. Okay. This part has to be improved. This part has to improve, right? You write more philosophical points that even though it is legalistic in nature, but still, through cooperative federalism, the constitutional design is such that different, aspirations of the state could be adjusted within the given administrative or the legislative machinery itself. Okay, so those sort of line has to be added. Okay, you have written very, very simple answer. Okay, now the content is good, but you have to improve upon legal use of words. Okay, so try to write more good words. See, these questions are checked by law professors. Okay, it is not a journalistic GS paper 2 one, right? So you have written answer more of GS paper 2, right? It has to be more legalistic. So whoever answer is that, please keep that in mind. Yes, same question is uniquely placed. Very good. Good heading. Location of power and capacity distribution. Very good. General line, good line. Field of legislation. Okay. No need to, you have to simply, it is a philosophical question. So you have to use the article to support the viewpoint or oppose the viewpoint, right? You have written case laws, but obviously you have not written very, comprehensively. That is good actually, right? You have to only mention the case law instead of writing into much detail. Okay, so that is okay actually. That is a good thing. Okay, now you have written this. Now you could have added what does it signify, right? What does it signify, right? So add what's purpose it serves. Okay, how it supports the answer, how it supports the question actually. Okay, and then state relationship. Okay. Now see, again you have written the whole. I've told you not to write the whole article in itself. Write the essence of it. That's it. Maintenance of communication. These two could have been clubbed here. Provides, yes, this is good. You have tried to club it into 2 lines. See how nicely you have clubbed 2 articles in 1 line. So that is why actually, that is how actually I wanted you to write. Okay. Improve content. Some of them is very nice actually, some of them is improvement is needed. Okay, otherwise it is a good answer. No need to write citation, right? Citation is a stupid thing to write, right? No need. But I know, in law college when I was there in the law faculty DU, there used to be a girl. She got almost 73%. That is a very huge marks, right? We are in 60s only, 73%. Now the answers she used to write, she used to not only write the case law, but also she used to write the citation, SCC 2018-64, volume 15. Okay, so that much level, but obviously that much level is not required, right? So you please don't do that, okay? Okay, and then polity have been variously defined. Okay. Good. That is a good intro. Again, it is a good intro. I mean, all the three copy have written very good intro. Dr. Ambedkar said rigidity and legalism are two weaknesses. Okay. Good. That's the relationship. Yes. We have very nicely clubbed it down. Theodore aspect. Again, you have went into the theory of doctrines related to the interpretation of the list, in more detail actually. But obviously, two lines are there. That is, can be done. Legislative subject. Okay. Again, shorten it up, right? I have told you these things. You have to shorten it up. You have to write a general answer, right? With respect to using legal language and only, bypassing the remark, okay, this case, right? Not go into detail of that interpretative list. Okay. Come to administrative lesson. Now, one thing I can see is everyone is missing that how does it impact the federal character of the constitution? Is it written federal character with certain tilt towards the union, right? So you write the provision, then write what is the basis of it, right? How does actually it affects the relationship? Okay, you have simply written that itself. The same problem was with the previous answer as well. Right. Okay. Right. No. You have to improve, right? You have only filled it with the legal provision only, right? See the question I have told you. Between, right, explain the provision regarding the central relationship, field of legislation and administrative power, right? So this is the question and this is the conclusion. I have told you 4 type of questions. I might not have told you, right? But normally if you are a law optional student, I must have told you. Whenever there is a question, something like that, there is a statement and in light of these, answer this. So basically what question is saying, this is the question and the conclusion you have to reach is this. Okay, like the question that I gave you in few classes back, that the PIL brings court, people and this together, right? Full stop. Discuss this statement in light of recent PILs, right? So you have to write about PIL and the conclusion is the first point. Okay, so this was the structure of the question. Okay, so please keep that in mind. And the last copy, let me take. This copy is very good. I think again it is of Ramya. I remember her name, right? Because she is one of the student. Okay. Tribe advertisement, dual polity or the power divider. See how nice, very good actually she have written introduction. The boundaries of the exercise of their power. See, the whole line itself seems to be very nice. Right? Everyone try to emulate her. Distribution of city power, good headline as well. Good. Okay, see, only in 2 lines they have written the whole 248, that is okay. This could have been made shorter. Centralizing tendencies. This subheading itself suggests that okay, she is focusing on the question. Now you have to shorten it, Ramya, okay? These all provisions you have to shorten it down. Okay, more shorter. Judicial principles. Yes, she only passing mentioned. Someone described the whole judicial principle. No, she have used this principle to support a particular point in question. Then that is okay. No need to go into that principle. What is that principle? Okay, so that need not to be written at all. Okay, so that is actually a very good answer. Power. Good. 356 state. 257. Maintenance of the railway. Good. more specific. One line, in fact, no, 2 line. That is okay. Full faith and credit clause. Okay. This is a unique article. No one have mentioned, right? That full faith and credit should be given to all executive act throughout the India, right? So that is again one of the provision that makes it more federal actually. Okay. Good. So written good answers actually. Okay. Yes, everyone. Now, I will take any question that you might have. Okay. Please go ahead. Ask your questions if you have any. Yes. And let me open this question as well so that if you have to see, you can actually see that questions. Yes. Anyone have any question? You can go ahead and ask me. Otherwise, we can wind it up. Yes. Okay. One by one. Yes, Isan, go ahead.
Sir, good afternoon.
Good afternoon.
So 2018, where there was a question which said, what are the constitutional safeguards and are these rights also available to an employee of a public corporation?
The answer is no.
That I frankly could attempt it then also, and since then I do not have any case law or any provision to how to attempt this one. If you could please help me with this.
In that question, you could have actually first differentiated between the civil servant and public servant, right? And then you said that some of the provision of the given to the public servant safeguard given in the constitution to the civil servant, has been provided to public servant, but also through different rules, CSR rules or other rules, whatever. Okay? But to be answering that question, right, you should have written that no, exactly you cannot say that just by the virtue it is provided to civil servant automatically it applies to everyone. That cannot be done. Okay. Right? So that particular mode of answering could have helped there.
So is there any case law you might?
There are multiple case laws. This is basically a concept, right? You cannot apply. You can cite administrative law as well, right? If something is a creation of a statute, then that is governed by the statute itself. That is a conceptual part, right? So even if there is no case law, you can practically write this line and you can go ahead with it.
Right. Sir. Thank you.
Okay. Yes, Mr. Navneet, go ahead.
Good afternoon, sir.
Good afternoon. Badai.
Sir, I just wanted to ask this question. You talked about the consultation with the UPSC members in case of transfer and change of procedure. Is that consultation binding?
Yes, consultation is binding. You have to consult him.
On the
let me answer you, Navneet, first. See, consultation is binding, but when the consultation is provided, that the fulfillment of that consultation is not binding. Okay, so authority, those who is the deciding authority, they may very well choose to ignore that consultation. But consultation is required. The procedural requirement has to satisfy.
Okay, sir. Okay, sir. Okay. Thanks.
Chaliye, so I think this is the sir. What is wider administrative and executive doers? What is that? I have already explained it, right? Yes, I will post the answer in the group. Not to worry. Okay. I have explained it, Sudarshan, right? I will upload, you see it again, okay? And even if then there is a problem, you email me, I will try to answer that, okay? Yes, so let us end for today's discussion. Hopefully you all, got what you are looking for, and tomorrow we will cover the next 3 topics. I think we will move into administrative. Okay, yes, thank you everyone.